I am Christopher Hansen, and you are fortunate, or I guess fortunate, because, yeah, we'll leave it at fortunate with this group, because we've probably tried to negotiate and argued about everything that could come up today, especially because it's our paperwork, but stuff that doesn't come up as well. And the purpose of this seminar isn't to give you an in-depth, how in the world do you negotiate an eminent domain clause, but to give you as broad an overview, because it's a basic commercial leases introductory primer. A lot of you have got tremendous experience, and some of you may not have any. So let me do a quick poll. How many people have negotiated on behalf of a client or yourselves 5 or more commercial leases? 15 or more. Okay. So we can get a sense of where we might want to delve in a little bit more. I start the morning with show and tell. And you'll notice that my outline in this course material is really brief and very few words, because pictures tell more words. Pictures tell 1,000 words, and it's true. So a little bit of background about me. In 1978, I got my broker's license and sold a bunch of residential real estate and thought, you know, that's fun, but let's get on to something more fun. And so in 1993, actually before that, started selling a bunch of commercial real estate. And in 1993, got my commercial investment real estate credential, which sounds really cool. And it was hard to do. And then the market imploded. Does anybody remember the savings and loans debacle from that cycle? I think I went 18 months without earning a commission. And when you're living on commissions as a commercial broker, that hurts. That hurts a lot. So I packed my bags, bought a motorcycle, and went around the country for a year, and then came back and said, now what? And what do you do when the commercial real estate market is still in the toilet? You go to law school. And I came out and found, as I was working through law school, that I was working for law firms, and found I liked practicing law a lot more than I liked being a broker. Sometimes people actually listened to what I had to say as a lawyer, when generally they don't as a broker. And that's part of the dynamic that I'm going to focus on this morning, and that's the interrelationship between brokers and lawyers. It is not, contrary to popular belief, just so that you can kill deals. That's really not what a lawyer's role is. More often than not, counsel can help put a deal together rather than kill one. More often than not. So there's been a dramatic change in our industry. There are cycles, and we're going through cycles again right now. And depending upon what market you're in, you're either having a really good time if you're in San Francisco or the Silicon Valley, or you're still having not such a good time if you're in Stockton or outlying areas of Sacramento or Wichita, Kansas. Because while the economy is recovering, employment is down below 6%, interest rates are still, well, free for interbranch, and 3.5, 4, 6, depending upon whether it's residential property or commercial property, employment is still lagging behind, and there's underemployment rather than full employment. The numbers are polluted by those who stop looking for work. They've timed out of unemployment benefits, and that's what unemployment numbers are measured by. So there is still this lag in the real estate business, the commercial real estate business as well. It's not as bad as brokers who have left the business to go do something else, and the ones who are still in the business are the survivors. They know how to adapt. They know how to guide their customers in adapting. And so how has the change in marketplace affected commercial leasing? And that's what we'll talk about. How has the change in marketplace affected the way you negotiate, or what the things are you negotiate in a commercial lease? I do a lot of work with real estate brokers, so this is probably real estate broker-centric, a presentation, but it applies to everybody. The first thing that a broker's got to think about is the broker's fiduciary duty to a customer. And the brokerage relationship is all about building trust with that client, whether it's the landlord of a shopping center, an office building, a retail space that's out in the suburbs, or something that's in a downtown mall like Westfield Mall in San Francisco, right? Medical office buildings, car dealerships, every kind of use has got particulars to it that the broker needs to be able to understand. So does the lawyer, because what you negotiate are different in those environments. I hammer on fiduciary duties a lot because it's always something you got to think about when you're dealing with the human being that is the representative of a company. Because who do you owe the duty to? The leasing manager who doesn't want to make a mistake and protect a job, who may or may not do what's the best thing for the company. I've had situations where that's come up, especially when there's side deals that a broker is making with an owner that can impede or impact a tenant. But we're not going to go into that today, are we? No. Okay. So it's important to remember who your client is. Yeah. So if you represent a landlord, they are not all mean, nasty, terrible people, especially for those who represent tenants. It is not always a function, I said, mind you, not always a function of pay the rent or get out of Dodge. It is sometimes that function. And landlords are actually, well, or they were actually, once upon a time, nice people. And if you represent landlords, they're wonderful people. But they have problems that you have to be able to be conscious of and address. In retail space, you got all of those shopping centers that are in outlying areas that are oftentimes today still empty. So that landlord's got bunches of housing all around it. They built the shopping center because the demographics and the forecasted economics made it a right thing to do. If you're representing a tenant that's trying to get back into retail space in one of those outlying markets, what kind of concessions do you want to get? Because the shopping center may still only be half full. Can you ratchet in rates where you're paying a little bit now and a little bit more as the shopping center gets better tenanted? Try negotiating that with a landlord that's trying to score as much money from anybody as they can. That creates an interesting dynamic in a negotiation. Office building space is the same thing. I talked about employment being light or lagging, especially in outlying areas, just as happened with retail space. Lots of spec office space got built, lots of companies closed. 80% of the businesses are small businesses, $5 million in gross revenues or under. Most of the leases that we'll negotiate for someone are not the full floor plate. It's not Facebook, it's not Salesforce. It's Joe and Martha starting up or expanding their cardboard box manufacturing company, or the accounting firm that's now going to get 6 more employees as opposed to the 2. Those are frequently the kinds of spaces that you'll spend most of your time negotiating, the 10,000 and 5,000 and less square feet. It's not the 100,000 foot warehouse. Sure, those deals happen, but what's the bulk of the work that you do? Landlords also have all kinds of problems with what can go wrong in that space. And how do you protect a landlord as you're negotiating the lease? A lease is really not much more than a prenup. It is a document that you use to how to solve a future problem. Because if everybody gets along, there are no contests, there's no arguments, there's no need for the litigators in the world to come in. Think about that for a minute. That's why lawyers are hated by brokers, because brokers are pure optimists and lawyers are pure pessimists. We're focused on what happens when something goes wrong. The landlord is looking for return on investment. How can I take the capital that I'm putting into this real estate and make it make a profit beyond the profit that I could get if I put it in mutual funds or tax-free muni bonds? So they get unhappy when they lose money. But the cycles have been the cycles, have been the cycles over and over and over again. It's not new. As a real estate broker, some clients, landlords and tenants, think of you as nothing more than the bookie. Whether the deal goes bad or the deal goes good, you get paid. That puts you way outside that circle of trust unless you've got a really, really good relationship with that client, be it the landlord or the tenant. And to get that really good relationship, you have to understand their business sometimes better than they do. Basic commercial leasing. What does that have to do with how you negotiate a lease? It has everything to do with how you negotiate a lease. Because if you don't know how your customer is going to use the space, you're useless to the customer when it comes to how you set up the letter of intent or the terms of that lease. Right? Am I blinking? Can anybody hear me? Okay. So, here is a statistic that I found shocking in terms of trust. The yellow is how much people don't trust real estate brokers. Lawyers, by the way, ranked underneath auto mechanics. So we've all got a problem in terms of how we can develop the ability to have the rapport to represent our clients. So that's just the landlord side. If you're representing the tenant, think of the number of hats that you have to wear. Sometimes you are the business advisor, sometimes you are the broker or the lawyer, sometimes you are the marriage counselor. It depends on how the interaction between the owners, the interest holders of that tenant are. How many are generally representing entities, corporate entities as a tenant? Individuals? There's only 3 people representing tenants in the room. And either you're a company or an individual. Once again, how many represent entities in their tenancy work? Okay. And individuals? So most of you are representing the corporate entity, right? Government. The government? Yeah, that doesn't really count as an individual or a company, does it? Yeah, it's a whole different animal. With a whole different set of bureaucratic overlays that you have to overcome, right? It's consensus and committee. There is no single decision maker. So imagine your joy as either a lawyer or a broker trying to represent this amorphous bowl of jello that you can't grab a hold of anyone who's a decision maker. How many have experienced that conundrum? What do you do?
Try to bring them together.
How?
Well, you show them it's in their best interest to work together on this particular. And somehow you work through it.
And how many committees does a government entity have to go through in order to be able to build that consensus?
We're rather streamlined, so it's just one.
Just one? How many have more than one? How many people have had to have it go through the real estate department, and then the finance department, and then a board of directors? So you've got 3 or more different groups with 3 or more different perspectives that you have to get consensus from. Isn't that fun? And then we're going to talk a lot more today about the differences in the kinds of tenancies. You've got medical office space that has infrastructure needs far beyond and very different from any other kind of space. And you've got office space today where it's all about clusters, right? It's all about making walls disappear and conversation pits and big whiteboards all along one wall. The day of the cubicle is over for most businesses, well, for most businesses in the San Francisco area anyway, right? And the Silicon Valley area. But what does that do to use, to load factors in a building. How many more parking spots do you need because you have more people per square foot? How many more bathrooms do you need because you have more people on a floor? Who's going to pay for the removal of all of those walls? Oh, wait, and the reinstallation, because you know that some law firm is going to want the space 2 years from now, and everybody has to have a private office in the law firm, because, you know, we like that. Right? So how do you set up a space so that it's not functionally obsolete for the next guy? Because who's had a tenant that's actually stayed in space more than 10 years? 1, 2, 3, 4? How many have had space that have turned over and had to be re-TI'd in 3 years? Yeah. So how you create the financial provisions in a lease to cover those expenses is something you need to know right from the beginning before you start negotiating the terms of that lease. It's the exit strategy. Retail space is another fun little factor. Brick and mortar was supposed to die, right? We were all going to be shopping on the internet, and retail space was just going to be gone, just completely obsolete. And now Amazon is building retail stores so that you can come in and feel and touch and see the item before you buy it online and have it shipped to you. The inventory in the store is more display than go in and purchase. Think about that as a change in dynamic for retail space. How do you get percentage rent on a retail space that isn't anything really more than a display case? If you're a retail shopping center lawyer or tenant, your focus is, okay, here's the base rent, here's the percentage rent. You want a percentage of internet sales? You're not going to get it. Good luck with that. Right? And so how do you plan for and factor in the ability to grab some of those dollars? Because, well, if they're using the space as display, isn't the space the trigger for that sale? And in traditional, typical retail space, you're getting a percentage of whatever is sold in the building. Fascinating conundrum. I don't know what the answer is. So, as a tenant's rep, you need to know everything. And your client, as a tenant, thinks every idea they have is a brilliant one. Their business is going to be the next Amazon or Google or whatever, right? It is going to be their idea is the best idea ever. And they don't need to worry about the risks of failure because there can't be any failure with it. It's so ironclad. It's so brilliant. It's the best idea anyone's ever had. Not so much. And that happens a lot. So the tenant wants to hurry, 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 hurry. And the lawyer is saying, well, maybe we should slow down and think about this for just a minute. And the tenant says, let's hurry, hurry, hurry. And the landlord just wants to get the space rented. So think of the tension. This is why, we're deal killers. We're bad, evil people. Because we're saying, slow down just a little bit. It's a real tricky path to walk between success and failure. And what happens if it goes wrong? Well, the first thing everyone does is pulls out that 40-page lease to find out what happens if it goes wrong. And that's where lawyers come in, right? These kind, wonderful, cheerful people who mix with brokers like oil and water. We don't like each other. I'm a broker, I'm a lawyer, I'm schizophrenic, right? So it really is about who's the client going to listen to? And there's this tug of war between the two interests. So part of the negotiation, believe it or not, is to understand how lawyers think about brokers and how brokers think about lawyers, because you've got to find a way to work together. So here is what lawyers think about real estate agents. Yeah, we can make that happen for you. It's a really good thing. Most lawyers would love a real estate agent to bring the client into the law firm and then disappear. Please don't, just thank you for the intro. We'll take over from here. And in the meantime, broyers, I coined a new word, are out there writing up leases and letters of intent and binding the client to all kinds of good stuff. Yeah. Just a little bit ago, I had $4.5 million loan on a shopping center, and the loan officer was really gung-ho to get this client's business and offered him a non-recourse 20-year fixed rate loan. And the client was on that like white on rice. And then we had a meeting at the client's office, and they brought in the senior lender underwriter. And I kind of chuckled and said, so you understand that the deal we're talking about is absolutely non-recourse. No carve-outs, no nothing, no bad boy provisions, no. And he blinked 3 or 4 times, and the salesman is over there going, yeah, yeah. And the underwriter is looking at him, and I didn't want to be in the car on the ride back to the bank because he had already bound the bank to that deal. So part of the fun of being a broker is if you're working with counsel in advance, you can skewer somebody because you can put terms in the upfront part of the deal when it's at the salesman level that no vice president in charge of anything is going to want to approve, but it's already been done. That's the basis of the deal. Is that sneaky, underhandedly wonderful negotiation? Sure it is. Does it happen every day? Only if you're thinking about it. So, brokers aren't the only ones that have, a bad rap. The attorneys, as seen by the brokers, we are no good, evil people. And all we're after is generating a bunch of legal fees and making things difficult. Now, brokers, as seen by themselves, are these hard-working, dedicated, overstressed, just trying to help a client kind of people. And every lawyer I ever have met knows that deep down inside, we're Perry. We can do no wrong. Trust us, we know. In a perfect world, everybody works together and it all comes together in a nice, wonderful collage of beautiness. That's a perfect world. That's the real world. It just doesn't happen. And you've got to make it happen. Again, brokers, the glass isn't half full or half empty. Are you kidding? It's completely full. Right? Because it's all how you look at it. And lawyers are all about fine print. Because we have to be. So, when it comes to fine print, let's talk about letters of intent. A letter of intent is really, how are we going to make this happen? What can we do? Let's go date for a while before we get married. And they swap back and forth, and it's really, we would love to be able to have a free look. Let's just kind of snoop around. Take the property off the market for just a little bit. We only need, 120 days to do some due diligence, and you don't need to lease it that quickly. Right. So how you get your look without any obligation is one of the very first steps in how you negotiate a lease. Now, this is a memorandum of understanding. This is merely a letter of interest. It's an expression of intent. It's not a contract. Unless, of course, there's a bunch of money sitting over there and the broker wants to get it, or the tenant thinks they're going to score a deal, or the landlord thinks that they're going to nail the tenant on some preferential lease that no one's really thinking about, and you put enough terms and conditions in that letter of intent that it can be deemed a binding contract. And we've seen that happen a number of times. And that's when Alex and I would talk about how you litigate something or how you try to avoid having to litigate something. Because you can get caught quickly in a letter of intent that you think is non-binding and turns out that it is. That's a scary proposition. So, now you've got this letter of intent, you're negotiating this lease, the keys now are to start to evaluate what are the pros and cons in the document. And we're going to go into excruciating detail on some of it later today, and we'll touch on highlights on some of it later today as well. But I really like common areas. Some common areas are really sparse, and there's really not a whole lot that needs to be done. A hose takes care of that common area. There are other common areas that might need a little work, and you can find yourself doing a wholesale renovation of common areas that you weren't expecting unless you build in some caps in what common area maintenance and renovation includes right from the very beginning. Because what if your landlord wants to take this and turn it into that? It's all common area. And welcome to the building. Because isn't your space going to benefit from this beautiful lobby? Your customers are going to love it. People will flock to you. And I'll be able, as the landlord, to raise the rent because it looks pretty. And thank you for paying for it, unless you build in protections from the beginning. We're going to talk about escalators, and not that kind. What are those automatic increases in tenant costs? Well, we have to build in reserves, because you know the HVAC system is going to have to be replaced, and inflation ticks up all the time. So CPIs with floors, but no ceilings. Go dark provisions. Well, what does 14 continuous days mean? And what happens when the anchor tenant goes dark but continues to pay the rent? The subtenants, or the subsidiary tenants, have go dark provisions. Go dark, who knows what a go dark is? Go dark is you can't abandon the space. You can't close the doors, turn off the lights, and continue to pay rent, because the shopping center is based on foot traffic. And your store is the generator for foot traffic. And if you go dark, especially if you're an anchor tenant, all of the subsidiary tenants that rely on that foot traffic suffer. So, there are provisions in leases that prevent you from going dark and just paying the rent. Or try to, and the penalties for those can be extraordinary. How you negotiate go dark provisions, lenders also, by the way, don't like to have people go dark and just pay rent. Lenders of the shopping center, never mind the lenders of the tenancy. So you have all kinds of overlays that you have to pay attention to with who does the lease provision impact beyond just the landlord and the tenant. It's all fun. Eminent domain, nobody ever thinks about eminent domain. It's one of those provisions, right, that it's all blah, 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 food, blah, 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 blah. Eminent domain provisions can be incredibly important to a tenant who's got goodwill built into having been in that space for 20 years. And now all of a sudden the city wants to widen the street or build an off-ramp. And now you can just move and don't worry about the loss in business. Because, well, you're an established business, and when you move, you won't have any drop-off. I think statistically it's 20-ish% of drop in business if you move even as little as 6 blocks away. How many lease provisions do you know allow the tenant to be able to interfere with the landlord's perceived exclusive right to negotiate for eminent domain proceeds? Lots and lots and lots. So, is it important to think about? Sure. Especially if, as a tenant, you're one of those folks that wants to be right by that freeway because you want all of that visibility, and is that where the new off-ramp is going to go? So you have to be thinking forward, what's the scope of planned development in that area? The other fun thing about eminent domain is if you are getting condemned, you get a 1033 as opposed to a 1031 tax treatment. And you can expand the ability to reinvest those monies for 3 years. Not just 45 and 180. That's a big deal for a landlord that's all of a sudden gotten a big check from a government entity, right? And then there's where the developer wants to come in and do a deal with the city. Just go ahead and condemn that 14 square miles of space. We'll take over and enter into a development agreement with you. Right? Well, thank you, say all of the people in those 14 acres. Where's the government purpose there? Well, we're condemning it in exchange for private development. Lots of ways to negotiate a lease, and it's all about who has the strength of negotiation. Some tenants, that 5,000 square foot tenant in a 150,000 square foot shopping center or office building, the strength of your negotiation is about there. Here's the lease, take it or leave it, have a nice day. If you're taking 2 floors of that 10-story building, you have a significantly different bargaining strength. The other kind of negotiation tactic is, well, sneaky. And there's a lot of people that try to do that. It generally doesn't work in the long run. Neither does overwhelming someone, because you get that reputation too, and you get stuck with the kind of tenants that are willing to take that on. There is the whole collaborative approach, which, you know, is in an ideal world. It doesn't often happen. And one of the reasons it doesn't often happen is because people don't actually pay attention to what the other side is asking for. So you talked about pulling out your yellow pen and hitting the deal points and then coming back to them. So who has kids? I know this is sounding like a silly segue, but it actually has some relevance. I have 2, and one morning they're screaming at each other in the kitchen because they want the last orange. It's like, what's up with the orange? Why are you arguing? I want to make orange juice. I want the orange because I want orange juice. And the other one is making waffles. And I want the orange peel because I want the zest to mix into my batter. And they're screaming bloody murder about each one wants the whole orange. I want the damn orange. Chop the orange in half, squeeze the juice, use the zest, you both get what you want. But they didn't ask each other why you wanted it. It was just, I want the orange. As a representative, you ask the question why, you can find that win-win solution. Sometimes. Not always. Sometimes. And then it comes to actually writing the lease. And we're going to talk a lot about that, but a lot of language in a lease just sounds like Greek to the clients. They don't understand what ratings of insurance companies mean or why it's important. But it is. And explaining it becomes critical. Translating a lease from one language the lawyers speak to the other language the businessmen speak becomes a critical part of any lease negotiation. And if you have bilingual, or if you have English as a second language tenants, there are in some cases obligations to actually translate the lease into the primary language. That makes life fun. So it's important to figure out who you are talking to and what their level of experience and understanding is as you're discussing what's in the lease. First drafts are always important. You want to be the guy that gets the first draft in the door, because then most of the time people are responding to your draft and not thinking about what they wanted in the first place. Which can be fun, because if you use the template, you have to work the template before you deliver it to the other side. How many times have we been asked? I know I have. I've drafted a lease, I've used a template, can you just look it over before we send it to the other side? Can we just look it over? They've pulled out something from a drawer of 1965. No, is the short answer. You've got to be able to be involved in that process from the very beginning. This is kind of what they end up looking like at the end of the day, where you've got the addendums and the additions and the scribble marks and the redactions, and a good lease will take some time to negotiate, and that time frustrates people. And most of the time, it is all about how to avoid the dangerous provisions of what can go wrong later. Lawyers Say, come on in, play with us, let us help you, trust us. And everybody else thinks, yeah, come on and work with us, because we're just trying to screw you. It's really not the case.